So today's topic is assignment of pre-construction condos. This is a topic I've been delivering for quite a while, and it's kind of self-explanatory. What are we assigning? Why is it different than other sales? So let me introduce myself. My name is John Polides. I'm a real estate lawyer. I've been a real estate lawyer for a long time, but before I became a real estate lawyer, I was a broker. And I was a broker for over 20 years before I became a real estate lawyer. So let's summarize what is an assignment. What is an assignment? So an assignment, it's the resale of something before the closing. So the assignment that we normally talk about is pre-construction assignments. Pre-construction assignments are resale of a new condo before the closing with the builder. But another word for that is what? What's another word for an assignment? People call it selling the offer. Have you ever heard that? Or selling the paper. Why do we say it's selling the paper? Or selling the offer? Why don't we say I'm selling a condo? What's the reason for that? So the basic mechanics of an assignment is we're selling our rights to the real estate by transferring the paperwork. We never become owners of the real estate. We never get financing. We never have a closing. We never pay land transfer tax. We're selling our paperwork. We're selling our legal rights. So I like to divide assignments into two categories: pre-sale, pre-construction assignments, or resale assignments. So what's the difference between a resale and a pre-construction? Does anyone know the difference? So if it's a pre-construction, what are the rules? So most pre-construction assignments, most builder deals have a provision in the agreement that says assignments are not permitted. Has anyone ever read this provision? Usually this provision says something to the like that buyer and seller agree that this agreement is a personal agreement between the buyer and the seller, and it may not, and the property may not be assigned, it may not be rented prior to the closing, and in the event the buyer advertises it for assignment, or advertises it for sale or lease, or lists the property on MLS, the buyer's deposit will be forfeit. So that's an absolute prohibition. So why does that matter? And then people say to me, well, the agreement says I'm allowed to do one assignment, but that wording doesn't change. So that wording may continue on to say, but if at the seller's sole and absolute discretion, the seller may allow the buyer to make an assignment for a fee, for a certain cost. So why do builders say they prohibit assignments, and then they also say they're going to permit assignments? And when they say we're going to permit assignments, they're going to say at our sole and absolute discretion. We're making up the rules as we go along. Why do they do that? So the builder is basically saying, I don't want you to compete with me. You're not going to compete with me with my address, with property that I own. All you gave me was a little deposit. Your rights come after closing. Then you can do what you want. But until the closing date, this is my property. I'm going to control it. Does that make sense? So the reality is the builder does not want you in competition. But there's other reasons too. So other reasons may be for not permitting an assignment is because if you read the builder's agreement of purchase and sale, the buyer gives representations and warranties to the builder. And the buyer says in the agreement of purchase and sale that they're going to occupy the property for their own use or for their immediate family member, and that they qualify for the rebate for owner occupiers for HST. Why is that important to the builder? What does the builder care if the buyer gets the rebate? It's not a trick question. You have to have read at least one agreement to understand. So the builder cares if the buyer gets the rebate because the agreement says that our price may be $500,000, but part of the price is that the buyer has to assign the rebate to the builder. That's an extra 25,000, a value. And if the buyer doesn't qualify to do that assignment of HST, assign the HST rebate, then the buyer has to pay the difference. So the price isn't really 500, it's really 525. Does that make sense? But the first page says it's 500. But the fine print says you must qualify for the rebate and assign the rebate to the builder. And in the event you don't qualify for the rebate, if you decide to rent the property or not move in, then you won't be qualified, then you must pay the extra 25,000. So these are two of the reasons the builder prohibits assigning. So resale deals, resale agreement of purchase and sale do not have usually an assignment prohibition. Doing an assignment is your right. You can assign any contract under common law unless it's a personal performance contract. So what's a personal performance contract? A personal performance contract says that only a certain person can do the work for you. So if I'm going to have my roof repaired, it's a rainy day today, and I'm going to have my roof repaired, do I care who is the roofer going up on the roof? Do I need personal performance, or do I just need professional trade service? But what if I'm hiring a musician? What if I'm hiring some famous musician like Drake, and he's gonna sing at my birthday party? And then instead of Drake coming, someone else shows up, Drake's cousin. Do I still want to pay him the same money?
No, you don't have to pay the same money.
So that's a breach of contract, right? So what's another way to make it a personal performance contract? Write it into the agreement. That's it. So that's what the builder does to our agreements. So unless there's a prohibition, you can do an assignment. And the builder drafts all of his contracts to prohibit assignments. Why do buyers want to do an assignment? Do they buy property so they could do an assignment? Some people do. Some people buy a property, they have no intention of closing, and they think they should do an assignment before the closing and just make money. Is that okay? Can they do that? It is possible, but does it have risks? A lot of risks, for sure. So let me give you an example of one of my clients who bought a property. This is quite a few years ago. She bought a property, and she came to me to review her agreement 6 months after she made the contract. So she came to me, she dropped off the agreement, and she says, this is closing in 2 years. I said, oh, very good. Let me take your information for title. Oh, she says, you don't need my information for title because I don't plan to ever buy it or ever move in. I'm planning to do an assignment. So do you think I should make her aware of something now? 2 years in advance? So the first thing I looked at was her agreement. So I read her agreement of purchase and sale with the builder, and the agreement had an absolute prohibition on assignment. It didn't have an assignment clause permitting assignment at all under any circumstance. So what's my job? My job is to make her aware of this. And I also made her aware that she has to be able to close. She has to have the funds and the financing for the closing date. And she says, John, I don't understand. My real estate agent told me I can do an assignment, and the only funds I have is the deposit I gave. I gave a 50,000 deposit, and I don't have any more money. And I can't get a mortgage because I'm on a pension, and I live in a rented basement apartment. I have no other money. So what was she doing? What kind of a deal was this? Was this an investment or was this a gamble? She has no way to close. She has no assignment right in the agreement. I would say it was a very silly gamble, because without an assignment right, she's going to run into trouble. Okay? And this lady I'm going to call her Helena. Yeah, Julia says it wasn't a good move. It was a very bad move. And she had the advice of her professional realtor who'd been in business for 40 years. Or you buy it, put deposit, and then we'll assign it. And she never even got her an assignment right. So I told them to go back to the builder. If they told you that they're going to give you the right to assignment, at least get us the right for an assignment. So 6 months later, the cooling off period was over. They actually went back to the builder's office and the builder gave them an assignment letter. They gave them an amendment to allow them to do an assignment because they had an email where they promised to allow them to do an assignment. And usually people do an assignment for different reasons. So usually it's because it's an investment and the value has gone up and they don't want to rent it. Now they just want to take the money and go to something else. Another reason is because they did plan to move in and now their plans have changed and they don't want to move in. People's plans change for a lot of different reasons. One reason may be that they decided to scale down and now they changed their mind. Another reason is because they need a bigger place than what they originally purchased. So people have a lot of different needs and ideas. People's plans can change over time. And the reality is that from the time you enter into an agreement of purchase and sale with the builder, 4 or 5 years can go by before the final closing date comes. So when I review agreements of purchase and sale during the 10-day cooling off period, in addition to capping all the costs, we also try to get a very liberal assignment right and also the right to rent during occupancy, because we don't know what's going to happen in 4 or 5 years. People's needs and plans change over time. Sometimes people even pass away. I've done assignments for estates where the estate does the assignment. Someone was planning to move in. They passed away, the value is up, and now their estate is flipping the unit. That's possible too. And the reality is values tend to go up over time. That's not a rule. They can go down, but what we've seen over the past few years is values go up. So remember, her problem was she had an arbitrary assignment provision that says we're not going to allow to assign. And then she thought that she solved it when she got the amendment. So she got the amendment, she brought it to my office. She says, phew, is everything okay now? Can I do an assignment now? I said, well, this amendment, it still says subject to the builder's sole and absolute discretion, acting reasonably or unreasonably. So how far along is the building? The building was still a hole in the ground. It wasn't scheduled to be built for almost 3 more years. I reminded her that it still says you're not allowed to advertise it for sale or for rent or for assignment. These are prohibitions. They don't go away. It's still contained in the agreement. So she left my office and I didn't think I'd see her for a while. Around 6 or 8 months later, she was waiting for me at the door, 9 o'clock in the morning. She's waiting at the door and she's very excited. She says, John, I have a problem. I'll let you guess what the problem is now. I got a letter from the builder. Guess what she did? She decided to list her assignment for sale on MLS. How hard was it for the builder to see it on MLS? And the builder's letter said, contrary to the prohibition in the agreement of purchase and sale, we notice on such a date you put the property for sale on MLS. You are now terminated. Your agreement of purchase and sale is terminated and your deposit is forfeitable. Is that good news or bad news? She says, John, I don't want to lose all my money. They've terminated me. Do you think she remembered I told her that you're not allowed to do an assignment or you're not allowed to advertise it? I don't remember anything. I sent her that in an email. My real estate agent said it was okay to list. She was blaming her agent and she wanted to blame me too for listing it. The second page of the letter was softer. The first page says, we have the right to terminate you. We have the right to forfeit your deposit. But if you remove the property from MLS and stop trying to advertise it for sale will allow you to close the deal, but your assignment right contained by amendment in the agreement, that is terminated. Because you're in default. Because whenever you have an assignment right, it says, if not in default, you can do an assignment. Now that she has a default, they're allowing her to cure the default partially, but they're taking away her assignment right. So I explained that to her, that she hasn't lost the right to close, but she has lost the right to assignment because she created a default. So what do we do now? She says, John, they might as well take it away from me because I have no other money. My only 50,000 was at what I gave for deposit. I can't close this. So what options do I give her? She's a senior citizen with no other money living in a rented apartment in a basement somewhere. She took a gamble. She was not a conventional investor who could have closed it and got the financing and rented it. She took a big gamble. Did she lose? When does the day come when she loses everything? Well, you're the most quiet crowd I've ever had. Closing, Julia says. So basically, she understood that she could not advertise it and she could not assign it. And she also understood that she's lucky she had to find another solution. So another solution would be for her to get a job. She says, where am I going to get a job at 67? I haven't worked for 7 years. I have a disability. Can she get a mortgage? She couldn't get a mortgage. She's already tried. She doesn't have the income to get a mortgage. So what other options does she have? She could find a partner, maybe get married, marry money. That's always an option, right? But those are less likely to happen. So the reality is we have a big problem. We have a big problem. I told her, go home. The closing is not coming for another 2.5 years or 3 years. So you might as well relax and we'll wait and see what changes. So a week later, she shows up again at my office waiting at 9 a.m. with her real estate agent this time, and they're both very excited. I said, what's happened? I thought maybe someone won a lottery. If they won a lottery, they can just pay for the unit, right? So they had an agreement to purchase and sale offer. They had an offer that they brought to me, and they wanted me to read it. I said, but we can't accept it because we have an absolute prohibition on assignment now. So is this offer a problem or is it good? Is it good news or bad news? From the one day it was on the market, they got an offer. But now they almost lost all their money, and she did lose the right to assign it. So what do we do with the offer? Do we negotiate it? The first paragraph of the offer says, seller warrants and represents that the seller is in good standing with the builder and has the right to assignment. Can she sign that agreement? Wouldn't she be making a false statement? This is a true story. Truth is stranger than fiction. So basically, we did negotiate the offer and we put in a clause that she's allowed to have lawyer's review, her lawyer's review, who was me, up until the very end. And this was a very detailed assignment agreement. The person who created the assignment agreement was another solicitor, and he had put in a lot of safeguards into the agreement. And he also had the assignees picking all the finishes. This is why the building was still unfinished. Most likely, you can do an assignment near the end. Even if she had the ability to do an assignment, the builder usually doesn't allow it until they've sold out their units. So right now, this builder has not sold out his units. So how did we deal with this assignment? We know the builder's not going to agree. We have a lawyer's condition until the end. So we also added a condition, conditional on builder giving us consent And we made it almost for 10 more months to get the builder's consent and the lawyer's review. And they agreed. So as the time went by, when we learned that the builder had sold out their units, I wrote to the builder and I said, my client wants to do an assignment. And they wrote back, they said, you don't have the right to do an assignment. So I wrote again to the builder's lawyer and I said, yes, but my client has a health problem, which she did. She had a disability. And I got the builder's lawyer on the phone, who I happen to know them. I knew her not very well, but we'd spoken before. And I explained to her that my client had to do an assignment because she had no ability to close on her own. And if it's a matter of money, we'll pay more for the assignment fee. And we were able to make a deal to permit an assignment, even though we had an absolute prohibition. At which point we waived all of our conditions, firmed it up, and we got the builder's consent to assignment. So that's what I would call a good assignment story. Assignments are rather complicated. I've never seen an assignment that's not slightly complicated. It does require some lawyers' review. I do see some people doing them on their own. Some brokers will do it for buyer and seller, and it gets very complicated. And when it gets complicated, it can backfire. I have another assignment story I want to tell you. This one came to me where I was acting again for a seller, an assignor, and the same agent double-ended it. He double-ended the assignment. What happened there was the assignor was already in occupancy. So we were assigning the occupancy at the same time as the agreement of purchase and sale. We're handing over the keys and we're releasing the money. So they had worded the agreement that there's an exchange of deposit, and also the profit of the assignor comes on the same day as we giving them the keys. We had to give them the keys and the builder's consent to assignment. In this situation, I met personally with the assignee's lawyer. He gave me the money, both the deposits, the prepaid deposits, and also the profit. So imagine that was $100,000. We signed a document called release of escrow. So we did a release of escrow document. And the reason that's important is that document allows me to release the funds to my client and he can release the keys to his client. He walked back to his office, which was just a few blocks away from my office. That's when I was at Yonge and Eglinton. And he called me when he got there. He said, John, do not release the money. Can he say this to me? Can he say, do not release the money? Do I have to listen to him? So under what circumstance can he say, deal's over, give me my money back? Are there circumstances that someone can say deal's over? There are certain circumstances if there's been a mistake, a substantial mistake or a fraud. So I listened to him. I said, what happened? Oh, he says, the agreement says that we're getting a parking. My client is supposed to get a parking, and there's no parking allocated to this unit. So I read the assignment agreement. In the blank where there's parking, it says no or none. I read the original agreement of purchase and sale with the builder. There was no parking mentioned. So I told him, I said, I don't know where you're getting the idea that you're getting a parking. Well, apparently his client had a sheet of paper that had a list of potential assignments. She went to the assignment specialty broker and she picked the cheapest unit with parking that she could afford. And there was a typo. So instead of none, they wrote one. Does that make sense? So none and one are two different things. So what is my answer now? Is this a substantial defect where they can get their money back? Who do I work for? I've released escrow now. So I can tell you for sure that the real estate agent who double-ended it had a negligence claim against them, and possibly the lawyer too, the lawyer who acted for the buyer, because she refused to close, she refused to go forward, she returned the keys, and she not only lost her 50,000 deposit, she also lost the 100,000 profit. So I believe between the two of them that there was an insurance claim that happened. There was a big mess up there. And unfortunately for that buyer, by the time this worked through the system, it probably took 1 to 2 years for this to come to some conclusion between insurance companies. So basically, assignments are tricky. I usually recommend that you have a lawyer's condition with every assignment. I've never seen one that comes perfect. And the whole idea is, like, you can say unprofessional work, but if you've never done one, or even if you've done 10 or 20, you're never going to become perfect at doing assignments. They are complicated. Each agreement is very dense. It's a long read, and you have to custom make your assignment based on each agreement of purchase and sale. They do have some things in common, and I talked about those common things already, okay? So we talked about HST. So this is the reason, the prohibition for HST. So this is just a recap. So from an assigner's perspective, in order to do an assignment, you must be in good standing with the builder, no breaches, no MLS attempts. You must have paid all of your further installments. Sometimes you're asked for warranties from the buyer, the assignee, that you're in good standing. And usually as an assignor, you have to pay the fee to the builder for the assignment. So builder's consent to assignment usually has a fee, builder's fee and a legal fee. So the legal fee may be $1,500 and the builder's fee could be a couple $1,000s. Sometimes we try to get a free assignment. If I review the agreement during the 10-day cooling off period, we'll usually have a free or very low price assignment. From the assigner's perspective, they may ask for additional security. So ask yourself, who is the buyer of an assignment? Why are they buying an assignment? Usually people who buy assignments are end users. And end users of condos are more likely to be first-time buyers. So they're going to need a mortgage. They may not have a big deposit, but they do have a job and they have some credit reference, credit record, and work record. So they can get a mortgage. Usually they're able to pay the whole price on the closing day, on the final closing day. So from the assignor's perspective, why would an assignor enter into an agreement of purchase and sale with an assignee where the assigner has given 100,000 and the assignee only gives him 20,000 and the rest on closing? Is that possible? Why should he do it? Why would an assigner take a low deposit and wait for the final closing after the assignee has moved in? Does anyone know? The reason an assignor does not goes along with an assignment and he becomes an unsecured creditor is because that's the marketplace a lot of times. Sometimes he doesn't want to close, and the reason he doesn't want to close, he doesn't want to take occupancy, pay the land transfer tax. And if he's satisfied with the credit of the assignee, he's willing to take the risk and wait until the final closing to get paid, both sometimes his profit and sometimes his deposit as well. So remember that the rights are based on the original assignment agreement. If the assignee does not close, the assignor has to close the deal with the builder. That's what the rules are. So the assigner's perspective is, I'm going to get my profit on closing, and I'm going to investigate and see that I'm assigning to the right person. And what we usually try to do is we try to get the deposits returned to us on builder's consent to assignment. From the assignee's perspective, why are we taking an assignment? Usually it's a good price. Usually it's a better price than when after the final closing comes. But some of the problems with assignments is we don't have capping of adjustments. If the adjustments are not capped, we can have a lot of extra costs on closing. And it's very difficult, like it's impossible to cap the adjustments with the builder. The builder's not going to agree. So who can we cap the adjustments with? Who can we cap the adjustments with now? Assignee?
Yeah.
Assignor?
Hi, John. This is Jagdeep. You can cap the adjustments with the original buyer.
Yeah, so you can go to the assignor and you can say, you should have done a better job. Thank you, Jagdeep. Go to the original buyer. You can say, you should have done a better job when you bought it during the 10-day cooling off period. You didn't cap the adjustments. And we need these capped now. We need some kind of a limit on it because the way the builder's agreement may be, it may have unlimited adjustments. And the big adjustments are worried about are development charges and educational development charges. Those sometimes can be $30,000, $60,000 and more, right? Usually, if I'm acting for the assignor, I say no further rights to assignment. So imagine people do assignments of assignments, double assignments and triple assignments. Unless there's a prohibition, they can keep doing assignments. So from the assignee's perspective, you may become a debtor. You may have liability for breaches of the original assignor. So if the assignor was late in paying something, or if they bounced the check, you're going to see on closing, there's going to be a bounce check charge. And that's when you have the opportunity to claw it back from the amount they're supposed to get from their balance. So if I'm acting for the assignee, I do want to have the profit going on the final closing date. So I can see the builder's statement of adjustments and see if there's any punishment that we're getting from the builder because of bounce checks or breaches of contract. Does that make sense? Sometimes the assignor does not qualify for the HST rebate, which means the assignee will not qualify for the HST rebate from the builder. So the builders are not quick to pass on the HST rebate. They may even make it a condition of the agreement and say, we're not going to give you the HST rebate. You have to apply directly to Minister of Finance. So what does that mean when the closing day comes? That means you need an extra $25,000. So why does the builder go along with assignments? Why doesn't everyone just close their deals and not do assignments? The reason I think builders go along with it is it's a market reality. Everyone wants to have the ability to do an assignment. It's a long time before the closing. The builder goes along with them. They collect a little fee. And really, it doesn't prejudice the builder's rights. I do see builders that refuse assignments if you're too early, way before occupancy, and they haven't sold their units. I also see builders refuse assignments when they say you're too late. They say we're going to have final closing in 2 weeks or 3 weeks or 5 weeks. So we don't have time to do assignments now. That's very common for them to say no, which means as a seller, you have to close. You have to be prepared to close. But there's a lot of advantages for sellers, assignors. You get your money back early, invest somewhere else. You avoid the occupancy fees, you avoid the closing costs, and you take advantage of a currently good market. The market is strong. Market is strong today. We did see that the market dipped a little bit for condos at the beginning of COVID, but that's all come back now, hasn't it? Are there multiple offers now for condos? For sure there are. The market's back. So assignment advantages for buyers, assignees, lower purchase price, lower land transfer tax. They get a new condo without the wait. Often they get to see the finished product, which you don't get to see if you're buying from a builder. There's less competition for assignments because they're complicated and people don't know how to deal with them. You get the full tear-in warranty. Usually you inherit the VIP incentives. Sometimes there's VIP incentives that get taken away on assignment. So you have to really read the agreement. I've even read agreements that take away the capping. I've seen agreements that have all the capping, but they say in the event of an assignment, you lose the capping. So whoever read that agreement for that client did not amend it to let them keep the capping. So that became unassignable later. So why don't assignments sell? Why do people fail to do their assignments. So one of the main reasons that assignments are unsuccessful is because you're not allowed to advertise. You're not allowed to put on MLS. You're not allowed to put on Kijiji. Even if the agreement has a provision that allows you to do an assignment based on builder's consent, they never permit you to advertise. And I'll take that back. There's a few builders from time to time will permit you to advertise. That's very rare. But if they're going to permit you to advertise, you need to get their permission in writing. So that's the number one reason, is no market exposure. The second reason is assignment deals are complicated. A lot of lawyers don't want to deal with them. It's a lot of work. And a lot of lawyers don't want to deal with it because they either don't know how to do it or they feel they can't charge for it. We charge for assignments. We charge something extra. And we spend the time and we get it done. Usually it's between $500 and $700. $500, $600, $650, somewhere around there. It's based on an hour and a half of time that we can review an assignment agreement and get everything that we need for our client, whether it's a buyer or a seller. Okay, and that also involves correspondence with the other party's lawyer. Another reason people don't buy assignments is because of the price. If the price is too high, people don't want them. Usually you price it a little lower than current market value when you go to assignment. Another reason that assignments are unsuccessful is the closing day is too far away. There's less buyers for a far away closing date. And if you can't show the unit, it's harder to show, harder to sell. And another reason that they fail, and I've told you this already, is the closing costs were not adequately capped. So if the closing costs are not capped, what that means is that your assignee will inherit these closing costs, and they may have an extra $30,000, $40,000, $50,000 on closing. So just recap, HST rebate may be added to the price if the builder doesn't consent to the assignee getting the HST rebate. That means your assignee has to have the $35,000 on hand. It does mean that they can apply after the closing to get the HST rebate directly from Minister of Finance. They just won't get it from the builder. But if they don't have the money and they're a first-time buyer, that will be a problem for them. These are some of the adjustments that we've talked about that we need capped. So we get these adjustments capped during the cooling off period in the first 10 days of signing up on the agreement of purchase and sale. So the reality is some of them are small and some of them can be big. Law Society fee is $65. Deposit processing fee may be $150 or $250 per check. And if there's 5 deposits, that's $1,250. 5 post-dated checks given. Usually I cap these during the cooling off period. The builder also may have mortgage discharge and admin fees built into the agreement. $500 to $800 right there. Development charges and educational development charges, we talked about those. Those are big expenses. Parks levies, public art, tiering enrollment. Tiering enrollment is more of an FYI. I tell everyone $1,200 to $1,400, but public art and parks levies can be thousands. And I told you already, educational development charges, depending on the wording, and development charges can be tens of thousands. A lot of people don't realize that in every agreement of purchase and sale, when you get appliances, and the appliances may be valued at $15,000 or $20,000, that you get the free appliances, but you still get charged HST on the appliances. So just do the math. It could be an extra $2,500 for the HST of the appliances. Even the builder says free appliances except for HST of the appliances. Hooking up to the grid, water, hydro, and gas meter installations. So there's a cost per meter, and I would say $500, $600, $800. Sometimes I see in agreements return check fee. These things are hard to fight. They're more of an FYI. 2 to 3 months maintenance free prepayment contribution to the reserve fund. We never win this, but the client has to be aware of it. Riaz, that's a good question, and I'm going to let you say that at the very end about how people are doing assignments today. Okay, so that's more of a marketing of assignments. Status certificate fee, electronic delivery of documents fee, these are all extras that your client will pay. So I will tell you that there's a lot of extra costs for assignments, and you should understand what they are. And if your client is educated and has everything disclosed to them, they won't complain. You have a duty to provide professional service and protect the best interests of your clients. You have to demonstrate reasonable knowledge, skill and judgment and competence in providing these services. You can't say, this is my first assignment and I didn't know what I was doing. So how do we protect you with assignments? I would tell you in all circumstances, you need 2 conditions. So the main condition is you need your client solicitor's review of the agreement, of the financial and non-financial terms of the agreement. And we also need a condition of the builder's consent to assignment. That's the minimum you should put in your assignment agreement. Now you're going to say, if the builder prohibits advertising, how are we going to do it? So is social media permitting assignments? It's still a breach of the agreement, but it's less likely you'll get caught. So you can go tell your friends verbally, it's probably unlikely you'll get caught, that you have an assignment. A lot of offices have their own assignment site, a Facebook site just for the office members where they advertise assignments. I think C21 has that. Is there a Facebook site for assignments, or sometimes they'll just send emails that are intended for directly? So you can say that's not advertising. It's harder to do assignments. The minimum you need for an assignment is you need the builder's consent to assignment built into the agreement somewhere. The prohibition on advertising is very hard to work around. A lot of people do it. They're very creative and they find ways of doing it. And some people specialize in assignments. And there's nothing wrong with someone specializing in it, in understanding what they're doing. It's a small niche market, but it does count for a lot of transactions. I would say every month we have 3 to 5 assignments that we review. And the reason we review them is we're an insurance policy for both the assignee and the assignor. We read the whole agreement of purchase and sale and the assignment agreement, and we make all the necessary changes so there's no problems for your client. We've been doing assignments for a long time.
Thank you so much for watching. If you like our video, please hit the like button, the subscribe, and even the little bell to get notifications, just so you can stay in touch and watch more of these great videos.